He never said that he remembered anything from that March 25th phone conversation with the Clinton people. Of course, that was days before he bleach-bitted the emails. He never said he had any factual knowledge of anything that happened on that call. Is that his basic statement? So I read the 302s. He didn't really provide any information.
I can't remember for sure it being the 302. You've probably seen it more recently.
Well, I saw one 302 said that he pled the Fifth. Obviously, he was given immunity. Another said that there was an invocation of attorney-client privilege at one time in one of the other summaries. So I'm just trying to figure out, what happened with Gambetta. Why was he not able to provide information? He had immunity. This was something that was much more fresh in his mind than previous conversations with Clinton people would have been. And yet you said he was credible. To me, feigning ignorance, that is not credible given the timeline where you have the New York Times saying that this server existed. The House immediately sends a subpoena. He has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where these things are now under a subpoena, and he has conversations with people who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach-bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why did you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI. Again, who knows what people don't tell the director, but I should have asked Mr. Gohmert. If there are agents of the FBI who are concerned or confused about this, please contact me. We'll get you the transparency you need to see that your brothers and sisters did this the way you would want them to.
All right, I'm out of time, but I will say just when I was in the military, you had said no one would be prosecuted. I mean, maybe that was just for civilian, but I can tell you that people, if you had compromised top secret information, there would have been a court-martial in your future, and I yield back.
Would the director care to respond to that?
No, fine.
It's a direct comparison to the finding of yourself that, as you stated in your news conference, that no prosecutor would prosecute somebody under similar circumstances.
I understood Mr. DeSantis to be expressing a personal opinion. I accept that at face value. I just haven't seen the cases that show me on the public record that that's true. But I accept his good faith.
The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Director, did you make the decision not to recommend criminal charges relating to classified information before or after Hillary Clinton was interviewed by the FBI on July the 2nd?
After.
Okay, then I'm going to need your help in trying to understand how that's possible. I think there's a lot of prosecutors or former prosecutors that are shaking our heads in how that could be the case, because if there was ever any real possibility that Hillary Clinton might be charged for something that she admitted to on July the 2nd, why would two of the central witnesses in a potential prosecution against her be allowed to sit in the same room to hear the testimony? Now, I've heard your earlier answers today. You said that, well, it was because the interview was voluntary and they were her lawyers. But I think you're skirting the real issue there, Director. First of all, the fact that it was voluntary, it didn't have to be, right? You could have impaneled an investigative grand jury. She could have been subpoenaed. And I know you've said that you can't comment on that, and I don't really care about the decision about whether or not there should have been a grand jury here. But since you didn't have one, it goes to the issue at hand about whether or not this interview should have ever taken place. with due respect to the answers that you've given, the FBI and the Department of Justice absolutely control whether or not an interview is going to take place with other witnesses in the room, because the simple truth is, if, under the circumstances as you've described, those interviews never take place. If there was ever any possibility that something Hillary Clinton might have said on July 2nd could have possibly resulted in criminal charges that might possibly resulted in a trial against her relating to this classified information, well, then, to use your words, Director, I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that. So, to me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails, correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails, correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. It's a low-level guy and you're trying to move up in the chain, you might think about it differently.
Well, he lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
Oh, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Gambetta?
Gambetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay, well, my time's expired, but I have one last question, and I think that's important. At this point, based on everything, do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken?
Yeah.
I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department and my colleague, Mr. Gowdy, here notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with bleach bits, so the FBI didn't review that. After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with bleach bit, so the FBI didn't review that. And also after the subpoena, backups of the Platte River server were manually deleted. Now, Director, hopefully that list is substantially accurate because it comes from your own documents. My question to you is this. Any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice. And to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton. And with that, I yield back.
Director, do you care to respond?
Very briefly, to ignore that which we don't have, we're in a fact-based world. So we make evaluations based on the evidence we're able to gather using the tools that we have. So it's hard for me to react to these things that you don't have. So that's my reaction to it.
The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you very much. Director Comey, thank you for being here. I know there are a lot of things you would probably much rather be doing than sitting on the hot seat, so to speak. And here's where I'm coming from on this. You've been asked a lot of questions today about the Clinton investigation. And what I'm hearing from folks back in Texas, and I'm just going to take a big picture view of this, is this stuff just simply doesn't pass the smell test on a lot of areas. You just had my colleague from Texas, Mr. Ratcliffe, list a long list of things that y'all didn't have in the investigation. You've been asked earlier today, well, would you reopen the investigation? What would it take to get you to reopen the investigation? We've had 5 people given immunity, which basically we got nothing when, perhaps a plea agreement or something else might have worked. You have your interpretation in your previous testimony before Congress that Section 793F required intent when, in fact, the standard is gross negligence. And it's just a long list of things that just have people scratching their heads going, if this were to happen to me, I would be in a world of hurt, probably in jail. And how do you respond to people who are saying that this is not how an average American would be treated? This is only how Hillary Clinton would be treated.
Yeah, look, I've heard that a lot, and my response is demand, when people tell you that others have been treated differently, demand from a trustworthy source the details of those cases. Because I'm a very aggressive investigator. I was a very aggressive prosecutor. I have gone back through 40 years of cases, and I'm telling you, under oath, that to prosecute on these facts would be a double standard, because Jane and Joe Smith would not be prosecuted on these facts. Now, you'd be in trouble. That's the other thing I've had to explain to the FBI workforce. You use an unclassified email system to do our business. And in the course of doing our business, talk about classified topics, you will be in big trouble at the FBI. I'm highly confident of that. I'm also highly confident, in fact, certain you would not be prosecuted. That's what folks tend to lump together. So I care deeply about what people think about the justice system, and that it not have 2 standards. It does not, and this demonstrates
But you look at General Petraeus in his handling of classified information. You look at, and I'll go back to what you're saying.
But when you look at it, demand to know the facts. I don't want to dump on General Petraeus because the case is over, but I would be happy to go through how very different that circumstance is than this circumstance.
And you talk about, you tell your FBI agents, if you do what we're investigating here with material from the FBI, you'd be a world of trouble. I would assume that could potentially be fired. Is Hillary Clinton she didn't get in any trouble at the State Department. The only trouble she's got now is trying to explain it to the American people.
Right, she's not a government employee, so the normal range of discipline that would be applied to FBI employees if they did something similar doesn't apply. And I think that's some of the reason for people's confusion, lumping these two together, and their frustration, but it is what it is. And all I can tell people is demand the facts. When people tell you, oh, so-and-so has been treated differently, demand the facts on that.
All right, so if somebody were to, let's just do a hypothetical. Let's say somebody here in Congress were to email my personal email some classified information, and I'm on I get my phone, it comes to my cell phone too, my personal email comes to my personal cell phone. I look at it and go, wow, that probably shouldn't be on there, and don't do anything. I mean, to me, that's being grossly negligent with classified information, and that's a violation of 793F. And that's exactly what Hillary Clinton did, I think. I mean, at what point do you get to intent? The classified information was on an unsecure server, you knew it was there, and you didn't do anything about it. To me, that's gross negligence, period. I would think I would be prosecuted for that.
Yeah, I'm confident that you wouldn't, but we just have to agree to disagree.
All right, if I ever get in trouble,
Don't
I'm
do
going to
it.
save this
Don't do
clip.
it. Well, I guess I can't control Congress. If you work for us, don't do it.
No, I have absolutely no intention of doing it. So again, I just want to say, don't get frustrated. We continue to ask these questions because we're not badgering you because we want to badger you. We are talking to you because the American people are upset about this and don't think it was handled appropriately. And that's the basis, at least, of my questioning. And I thank you for appearing here.
And I totally understand that. That I think there are lots of questions people have, which is why I've worked so hard to try and be transparent. There's never been this kind of transparency in a criminal case, ever. But because I understand the questions and the importance of it, I've tried. But I hope people will separate two things: questions about facts and judgment from questions and accusations about integrity. As I said before, you can call us wrong, you can call me a fool, you cannot call us weasels, okay? That is just not fair, and I hope we haven't gotten to a place in American public life where everything has to be torn down on an integrity basis just to disagree. You can disagree with this. There is just not a fair basis for saying that we did it in any way that wasn't honest and independent. That's when I get a little worked up, sorry.
I'm out of time.
The chair recognizes the gentleman from Michigan, Mr. Bishop, for 5 minutes.
Thank you. Thank you, Director Comey. I appreciate your testimony here today. Just in follow-up to all this discussion regarding the Clinton investigation, specifically with regard to the interview of Secretary Clinton, I'm holding in my hand a memorandum from Deputy Attorney General James Cole. It's dated May 12, 2014. This memorandum was issued to you and others on the policy concerning electronic recording of statements. Are you familiar with this memorandum?
Mm-hmm.
The policy establishes a presumption that the FBI will electronically record statements made by individuals in their custody. Now, I know that Secretary Clinton was not technically in custody, but the policy also encourages agents and prosecutors to consider electronic recording in investigative or other circumstances where that presumption does not exist. The policy also encourages agents and prosecutors to consult with each other in such circumstances. And given the magnitude of what we've been talking about today and the huge public interest and demand for information with regard to the public trust, I think this is specifically important to this discussion. Now, you're aware of this policy, correct?
Right, that applies to people that are in handcuffs.
But not. It also applies to. The policy also encourages agents and prosecutors to consider electronic recording in investigative matter and other matters where that presumption does not exist. Does
Sure.
it not?
The FBI doesn't do it, but sure, I understand that they encouraged us to talk about it.
So did the agents then did not consider to conduct the interview in a recorded situation then?
We do not record non-custodial interviews.
Okay.
Now, maybe someday folks will urge us to change that policy, but we don't, and we sure wouldn't want to change it in one particular case.
Well, that's the policy. I'm just reading the policy that's issued by the Deputy Attorney General, James Cole, that is to you and to others in the Department of Justice that establishes the policy. So if you don't do it, I assume that you're doing it against the policy of the Department of Justice.
No, that policy only governs custodial interrogation, so people who've been locked up. We do not, and it is not inconsistent with Department of Justice policy, record non-custodial, that is voluntary interviews where someone's not in our custody.
Well, I'm reading this differently then, because it does say that there's an exception that it is within your discretion to record such.
Well, sure, you could, and I don't know, maybe some other federal investigative agencies do. The FBI's practice is we do not record non-custodial interviews.
Okay, thank you, Director. I want to pivot, if I can, and build off Representative DeSantis's questions with regard to the refugees attempting to enter the United States, and specifically with regard to Syrian refugees. Wondering if you can tell me, we've talked about this process and the fact that we do not have a process in place that we can rely upon. You've indicated before when you testified, and I asked the question, that we just simply don't have enough information to ensure that we have the information that we need to ensure that these people are not a threat to our country. Can you expand upon that now after a year? Can you tell me whether or not we've got more information, more capabilities to vet these refugees? And I say this because in my district in Michigan, in this fiscal year, Michigan has taken the fourth most refugees of all states, 4,178, and we've taken the third most for Iraq, the second most from Syria. Michigan has absorbed an enormous number of refugees, and I think you can understand our concern with regard to the fact that we don't have information necessary to identify whether or not they're a threat. Can you assuage my concern, the concerns of my constituents, that we have a system in place that we can vet these individuals and they don't pose a threat to our country?
I can assuage in part and restate my concern in part. Our process inside the United States government has gotten much better at making sure we touch all possible sources of information about a refugee. The interview process has gotten more robust, so we've gotten our act together in that respect. The challenge remains, especially with respect to folks coming from Syria. We're unlikely to have anything in our holdings. That is, with people coming from Iraq, the United States government was there for a very long period of time. We had biometrics, we had source information. We're unlikely to have that kind of picture about someone coming from Syria, and that's the piece I just wanted folks to be aware of.
Has anything changed in your vetting process? Have you updated it? Do you have any concerns with regard? We've seen an increased terrorist activity in the last 6 months, including New York, New Jersey, and Minneapolis. Has anything changed in the vetting process? Can you be confident that foreign fighters or other refugees entering the country are not planning future attacks on our country?
Well, as I said, over the last year, since I was last before you, the vetting process has gotten more effective in the ways I described. I'm in a business where I can't ever say that there's no risk associated with someone, so we wake up every day in the FBI worrying about who might have gotten through in any form or fashion to the United States or who might be getting inspired while they're here, so I can't ever give a blanket assurance.
Director, I respect your opinion. And this is not a policy question. I'm asking you based on your personal opinion as a law enforcement officer that we rely upon to keep this country safe. Is there anything that you would do to ensure, as you said, that our country is safe with regard to this refugee process?
Anything that I would do? Anything
that you do. Any recommendations you have for Congress, for this country, that would ensure our safety?
Yeah, I shy away from assurances of safety given the nature of the threats we face. I do think that there may be opportunities to do more in the social media space with refugees in particular, and I talked to Jay Johnson yesterday about it. I know there's a work in progress. So much of people's lives, even if we don't have it in our holdings, may be in digital dust that they've left in different places. Are we harvesting that dust on people who want to come into this country in the best way? And I think there may be ground for improvement there.
Thank you, Director. I will yield back. But, Mr. Chairman, I'd ask unanimous consent to enter the memorandum that I referenced earlier from dated May 12, 2014, into the record.
Without objection, it will be made a part of the record. The chair recognizes the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I appreciate you being here. You are, I believe, forthright, much more so than you said is in any criminal case we've had. But I'm also still in the military. I'm still in the Air Force Reserve. I went to my drill back in July. I was hit by an amazing amount of questions from different service members on this issue of how does the former Secretary of State get to do this, and yet we have members of the military who are prosecuted all the time. Your statements earlier were fairly startling when you said, I don't know of anybody else that's been classified as this. Just since 2009, the Department of Justice has prosecuted at least 7 people under the Espionage Act, all for very similar cases. Now, you said go look at the facts. Well, we're looking at the facts in these cases. The interesting one, and you know, you said that in looking back at your investigation, mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All right. Well, it didn't take nothing but a simple legal search to find a Marine that fallen. Now, I guess their name is not Jane or Joe, so they did get prosecuted. Okay, and this is the issue under 18 U.S.C. 793F, gross negligence. This is what the Marine did. They took classified information that was put into a gym bag, cleaned out, washed, and took. All right, simple mishandling. Court of Appeals actually upheld this case, and this is what they said, that the purpose of federal espionage statutes is to protect classified documents from unauthorized procedures, such as removal from proper place of custody, which would mean how you deal with this. Regardless of means of removal, it was apparent gross negligence and was approximate cause of the document's removal. It is, and they quoted United States v. McGinnis, said it is clear the Congress's intent to create a hierarchy of offenses against national security ranging from classic spying to merely losing classified materials through gross negligence or the mishandling of. It was sort of also ironic for me that when I had to go back in July in this past month when I went back, I had to do my annual information assurance training. They went through everything that we have to do with handling classified information. I have been in a war zone. I've been in private. This is just common knowledge among most everybody in the world, obviously not to the Secretary. How can you then explain to me this Marine's mistake in taking classified documents or mishandling them is more severe than the Secretary of State who sent and received classified emails on a regular basis, including those that were originally classified, not those that were classified later, but were originally classified?
Yeah, first of all, I'm familiar with the case, and I'm quite certain it's not a 793F case. It was prosecuted
His
as
conviction was under 793F.
Yeah, I don't think, I mean, I'll go back and check again. I'd urge you to, too. I'm pretty sure it's not under the gross negligence prong of 793F. But it's a Uniform Court of Military Justice prosecution, not by the Department of Justice. Am I remembering correctly?
This was from and is appealed out in the U.S. the Court of Appeals for the Armed Forces did actually hold it on this. Yes.
But regardless, I think even I don't think this is under the same provision, but even there, that's a case involving someone who actually stole classified information, hard copies. What people need to remember, and I don't say this to make a little of it. I think it's a very serious matter. What happened here is the Secretary used an unclassified email system, her personal system, to conduct her business.
And let's just stop right there. That in and of itself, and I understand this, Dr. Comey, we've been through it. You've been through a lot of questions. I apologize. But let's just come back to the basics here. We're trying to parse that I didn't have such a Sandy Berger or all these others who've been prosecuted. They took a hard copy. In today's society, and even understanding if you go through any information assurance class, anything else, they tell you it cannot be on a personal laptop. In fact, there was another chief petty officer who had classified information on a personal computer. It went back and forth at war zone. That is not physical documents. It's on a, to parse words like that is why the American people are fed up. They're fed up with the IRS commissioner when he does it. They're fed up here. I'm not attacking your, I think you're one of the more upright people I've met. I think you just blew it. I think the Attorney General blew it. I shared this with her. And I think when we come to this saying there's no other way that you can say that there's no others that resemble this, as a lawyer, you're taught all the time to take facts and put them, they may not be exact, but they fit under the law. You can't, I mean, so I guess maybe I'm going to change the question because we're going to go down to a dead end. You're going to say it wasn't.
Can I
but let me ask you this. I want to change questions. Do you honestly believe that a lady, a woman of vast intelligence, who is the First Lady of the United States, who is a senator who had access to classified information, all the members here do, who is Secretary of State who had even further classification ability, even beyond what we have here, do you believe that in this case, honestly, she was not grossly negligent or criminal in her acts?
First of all, I don't believe anyone other than my wife. My question is, what evidence do I have to establish that state of mind? And I don't believe I have evidence to establish it beyond a reasonable doubt.
Then really what we're saying here is this. And this is in essence what you're saying. You said, I can't prove it, and I understand. There's a lot of folks out there in the law that, they come to us all the time. I'm an attorney as well, and they come to and say, it's not what we know, it's not what we think, it's what we can prove. I get it. But here's the problem with this, and this is the person who's asking to lead this country. If she can hide behind this and gleefully get approval from the FBI through an investigation, which has been covered here thoroughly, then I just do not understand. She is either the most arrogant, which probably so, or the most insanely naive person we've ever met. Because when I actually show evidences of basically the same thing, which you can take facts and correlate to law, this is why the armed forces right now have the new term called the Clinton defense. I didn't know. I didn't mean to. It's on my thing. It's the Clinton defense. With questions like this, Director, we have give the ability now to where nobody takes this seriously. And this is why people are upset. When it was originally classified, she can tell all the stories she wants. She can have the backup from you that no prosecutor, which is, again, amazing to me, that a law enforcement would tell the prosecutor, because how many times I've been on both sides of this, where the law enforcement agent said, I'm not sure we have a case here, but when the prosecutor looks at it, the prosecutor says, yeah, there's a case here. I don't really, frankly, no offense, care what, if I'm in prosecuting, what the law enforcement officer, if I can see the case and I can make it, that's my job, not yours. And yet now we have a whole system that has been turned upside down, not because I don't believe your honesty of your people, but I believe you blew it because you, frankly, didn't have the whole situation into effect where the FBI would look political. And unfortunately, that's all you've become in this. And it's a sad thing because y'all do great work. You have do great work, and you will do great work. But I think it's time to start, we just bring down the curtain. There's a wizard behind the thing, this Hillary Clinton, who is playing all of us because she's not that naive. She's not stupid. She knew what she was doing because she was simply too bored. If she, God forbid, gets into 1600 Pennsylvania Avenue and just gets bored with the process, then God help us all. Mr. Chairman, I yield back.
Mr. Chairman, there's only two.
The Director is permitted to respond.
Yeah.
Two pieces of that I need to respond to. First, you said hiding behind something. This case was investigated by a group of professionals. So if I blew it, they blew it too. Career FBI agents, the very best we have were put on this case, and career analysts. We are a team. No one hid behind anything. American citizens should insist that we bring criminal charges if we're able to investigate and produce evidence beyond reasonable doubt to charge somebody. That should be true whether you're investigating me or you or Joe Smith on the street. That's the way this case was done. It's about evidence. And the rest of it I'll let go.
Mr. Chairman, I will, and I apologize if you're not saying just a comment. I'm not, this is the problem, though. When you take it as a whole, it's been said up here, this is a unique case. You've talked about it being a unique case. Director, this is a unique case because I truly, and I don't think you convinced hardly anybody except your own group, I don't think you ever said they couldn't blow it. They blew it. Anybody else would have been prosecuted under this. In my humble opinion,
You're just wrong.
you say
You're just
no.
wrong. We'll just have to agree to disagree.
Well, unfortunately, there's a lot to disagree on this. Thank you, Mr. Chairman.
Time of the gentleman has expired. The gentleman from Idaho, Mr. Labrador, is recognized for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I've always appreciated your testimony before this committee, and I respect the work that you do for the FBI. When you made your recommendations to the Department of Justice to not prosecute Hillary Clinton, I actually disagreed with your decision, but I appreciated your candor in explaining to the American people and to us those recommendations. Since that decision, I continue to view you as honorable and a strong leader for the critical federal agency. In fact, I did 20 town hall meetings over the recess, and I was lambasted at every one of them. In fact, I think I lost votes because I defended your integrity at every one of those town hall meetings. And I told them why, even though I disagreed with your conclusions, I thought you came to it from an honorable place. However, as more information has come to light, I question the thoroughness, and I'm not questioning your integrity, but the thoroughness and the scope of the FBI's investigation. In the past week, we have learned of the grants of immunity to several key witnesses in the Clinton investigation, including Hillary Clinton's former chief of staff and one of the individuals responsible for setting up her server. I'm really disappointed by this revelation and confused as to why these immunity grants were necessary and appropriate given the circumstances. It appears to me that the FBI was very early in this investigation too willing to strike deals and ensure that top officials could never be prosecuted for their role in what we now know was a massive breach of national security protocol. We have a duty to ensure that our FBI is still in the business of investigating criminal activity. So at what point in the investigation was Cheryl Mills offered immunity?
Cheryl Mills was never offered immunity, not to quibble, but she was given letter immunity to govern.
At what point?
June of 2016, so June of this year, so about 11 months into the investigation.
So, and to be clear, was she offered immunity for interview and potential testimony or for turning over the laptop as evidence?
Turning over the laptop as evidence, it governed what could be done in terms of using it against her, that laptop.
To your knowledge, was Cheryl Mills an uncooperative witness prior to the immunity deal?
I think our assessment was she was cooperative. I forget the month she was interviewed, but she was interviewed fully before that.
And she always cooperated?
I think our assessment was, again, this is the odd way I look at the world, we had no reason to believe she was being uncooperative.
So could this investigation have been completed without these grants of immunity in place?
In my view, it couldn't be concluded professionally without doing our best to figure out what was on those laptops. So getting the laptops was very important to me and to the investigative team.
So in your vast experience as an investigator, as a DOJ attorney, now as an FBI director, how many times have you allowed a person who is a material witness to a crime you're investigating to act as the lawyer in that same investigation?
Well, to let is what I'm stumbling on. The FBI has no power to stop someone in a voluntary interview.
You're speaking, let's just be honest. The FBI allowed Cheryl Mills to act as the attorney in a case that she was a material witness. How many times have you done that?
In the same sense that I'm allowing you to question me.
How many times have you done that?
I can't stop you from questioning me.
How many times have you done that prior?
I have not had an experience where the subject of the interview was represented by a lawyer who was also a witness in the investigation.
Okay, so you have never had that experience?
Not in my experience.
You prosecuted terrorists and mobsters, right?
Correct.
And during your time in justice, how many times did you allow a lawyer who was a material witness to the case that you were prosecuting to also act as the subject of, as the attorney to the subject of that investigation?
Yeah, as I said, I don't think I've encountered this situation where a witness, a lawyer for the subject of the investigation was also a witness of the investigation.
So this was highly unusual to have?
In my experience, yes.
Okay. In your answer to Chairman Chaffetz, you indicated that you had no reason to disbelieve Paul Gambetta when he told you that he erased a hard drive on his own. Is that correct?
Correct.
However, in the exchange on Reddit, he said, I need to strip out a VIP's email address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Those two statements are not consistent. How can you say that he was truthful when he told you nobody told him to act this way, but yet you saw this Reddit account that says where they told him that he needed to act in this way?
I think the assessment of the investigative team is those are about two different subjects. One is a year before, in the summer of 2014, about how to produce emails and whether there's a way to remove or mask the actual email address, the HRC, whatever it is, .com. And the other is about actually deleting the content of those emails sitting on the server.
It seems like in your investigation you found time after time evidence of destruction, evidence of breaking iPhones and other phones, all these different things, but yet you find that there's no evidence of intent. And I'm a little bit confused as to your interpretation of 18 U.S.C. 793F. On the one hand, you've said that Secretary Clinton couldn't be charged because her conduct was extremely careless, but not grossly negligent, correct?
That's not exactly what I said.
That's what you said today. But you've also said
I
there
don't
was
remember
no
saying that.
evidence of her intent to harm the United States. So, but you'll agree that a person can act with gross negligence or even act knowingly without possessing some additional specific intent. So which is it? Is it a lack of gross negligence that she had or a lack of intent?
In terms of my overall judgment about whether the case was worthy of prosecution, it's the lack of evidence to meet what I understand to be the elements of the crime, one, and two, a consideration of what would be fair with respect to how other people have been treated. Those two things together tell me, and nothing has happened that's changed my view on this, that no reasonable prosecutor would bring such a case. The specific intent question, yes, I agree that specific intent to harm the United States is a different thing than a gross negligence or a willfulness.
So just one last question. You talked about Mary and Joe. And Mary and Joe would be disciplined at the FBI if they did what Hillary Clinton did. If Mary and Joe came to you and asked for a promotion immediately after being disciplined, would you give them that promotion?
Tough to answer that hypothetical. It would depend upon the nature of the conduct and what discipline had been imposed.
And what if they ever asked for a promotion that would give them management and control of cybersecurity of your agency and the secrets of your agency after they had done these things? Would you give them that promotion?
That's a question I don't want to answer.
All right.
The time of the gentleman has expired. The chair recognizes the gentlewoman from California's Ms. Walters for 5 minutes.
Oh, sorry.
Hi, Director Comey. Despite the absence of an intent mens rea standard in 18 U.S.C. Section 793F, you have said that there has never been a prosecution without evidence of intent. Thus, the standard has been read into the statute despite the specific language enacted. What exactly are the legal precedents that justify reading intent into the statute?
Well, my understanding of 793F is governed by a couple things, three things, really. One, the legislative history from 1917, which I've read, and the one case that was prosecuted in the case. And those two things combined tell me that when Congress enacted 793F, they were very worried about the gross negligence language and actually put in legislative history, we understand it to be something very close to willfulness. Then the next 100 years of treatment of that actually tell me that the Department of Justice for a century has had that same reservation because they've only used it once. And that was in a case involving an FBI agent who was in an espionage context. So those things together inform my judgment of it.
Considering the importance of protecting classified information for national security purposes, a lot of people disagree that an intent standard should be read into that statute. What specific language would you recommend we enact to ensure gross negligence is the actual standard for the statute, not intent?
I don't think that's something the Bureau ought to give advice on. It's a good question as to what the standard should be. I could imagine federal employees being very concerned about how you draw the line for criminal liability, but I don't think that's something we ought to advise on the legislation.
Okay. Should we enact a mens rea standard for extreme carelessness for the statute?
Same answer, I think, is appropriate.
Should we enact a civil fine?
A civil fine for mishandling classified information? I don't know, actually, because it's already subject to discipline, which is suspension or loss of clearance or loss of job, which is a big monetary impact to the people disciplined. So I don't know whether it's necessary.
Okay, I want to change subjects
Okay.
For my next question. As you know, the number of criminal background checks for non-criminal purposes, such as for employment decisions, continues to increase annually. I don't expect that you have this information on hand. However, would you be willing to provide the committee and my staff with the number of criminal history record checks for fingerprint-based background checks that the FBI has conducted over each of the past 5 years? And what are your thoughts regarding whether the FBI has the capacity to process the increasing number of background check requests?
I'm sure we can get you that number because I'm sure we track it, so I'll make sure my staff follows up with you. I do believe we have the resources. Where we've been strained is on the background checks for firearms purchases. The other background check processes we run, my overall sense is we have enough troops to do that. We charge a fee for those, and I think we're able to generate the resources we need.
Okay. Thank you. I yield back my time.
Okay.
Could the gentlelady yield to me?
Sure. I'd be happy to yield to you.
Thank
Ms.
you.
Issa.
Thank you. Director, some time ago you appeared before this committee and you told us that you had exhausted all of the capability to unlock the San Bernardino iPhone, the 5C. Did that turn out to be true?
Still true.
That you had exhausted all of your capability?
At the FBI had, yes.
So shouldn't we be concerned from a cyber standpoint that you couldn't unlock a phone that, in fact, an Israeli company came forward and unlocked for you, and basically a Cambridge professor or student for $90 is shown also to be able to unlock and mirror or duplicate the memory? And this is purely a question of you apparently do not have the resources to do that which others can do. Isn't that correct?
I'm sure that's true in a whole bunch of respects, but first I got to correct you. I'm not confirming. You said an Israeli company. I'm not.
Well, okay. A contractor for you reported to be for $1 million unlocked the phone. So I would ask you to confirm the phone got unlocked, right?
Yes, it did.
Okay. So the technology could be created outside of ordering a company to essentially clandestine or re-engineer their software for you, correct?
Yeah, in this particular case, yes.
Okay, and so you lack that capability. How can this committee know that you're in the process of developing that sort of technology, the equivalent of the Cambridge $90 technology?
How can the committee know?
Yeah. I mean, in other words, where are the assurances that you're going to get robust enough? We have an encryption working group that was formed between multiple committees to no small extent because of your action of going to a magistrate and getting an order because you lack that capability, and we're trying a new technique of ordering a company to go invent for you. The question is, how do we know that won't happen again, that you will go to the court, ask for something when, in fact, the technology exists or could exist to do it in some other way, a technology that you should have at your disposal, or at least some federal agency should, like the NSA?
Well, first of all, it could well happen again, which is why I think it's great that people are talking about what we might do about this problem. It's an interesting question as to whether we ought to invest in us having the ability to hack into people's devices. Whether that's the best solution doesn't strike me as the best solution, but we are, and I've asked for more money in the 17 budget, trying to invest in building those capabilities so when we really need to be able to get into a device, we can. It's not scalable, and I'm not sure it would be thrilling to companies like Apple to know we're investing money to try and figure out how to hack into their stuff.
Well, isn't it, and I'll be brief, isn't it true that we have clandestine organizations who have the mandate to do just that, to look around the world and to be able to find information that people don't know you can find, keep it secret, get it out there? And my question to you is, shouldn't we, instead of giving you the money, simply continue to leverage other agencies who already have that mandate and then ask you to ask them to be your conduit for that when you have an appropriate need?
And that's a reasonable question. It may be part of the solution. Real challenges in using those kinds of techniques in the bulk of our work because it becomes public and exposed. But that has to be an important part of the conversation.
Thank you. Yield back.
The chair recognizes the gentleman from Arizona, Mr. Franks, for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here, Director Comey. Director Comey, the last thing I want to do is to lecture you on anything related to the law, because I think you've given your whole life to that effort. And I guess in the face of so many things already having been said here and asked, that all I can do is to try to sort of associate this in a reference of why there is a rule of law. You know, we had that little unpleasantness in the late 1770s with England over this rule of law, because we realized there's really only two main ways to govern, and that is by the rule of men or the rule of law. And sometimes it's important for all of us just to kind of reconnect what this whole enterprise of America is all about. And I, again, don't seek to lecture you in that regard. And I know, and you have to forgive me for being a Republican partisan here, because I am very biased in this case. But I know that when you interviewed Mrs. Clinton, you were up against someone that really should have an earned doctorate of duplicity and deception hanging on her wall. I don't know that you probably could have interviewed a more gifted prevaricator. So I know you were up against the best. But having said that, when I read the law here that I know so many have already referenced, I think maybe that's the best way for me to do that. 18 U.S.C. 1924 provides that any federal official who, quote, becomes possessed of documents or materials containing classified information of the United States and knowingly removes such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location shall be fined under this title or imprisoned for not more than 1 year or both. Now, I didn't miss one word there. It does not require, that section does not require an intent to profit. It doesn't require harm to the United States or otherwise to act in any manner disloyal to the United States. It only requires intent to retain classified documents at an unauthorized location. And I believe, sir, in all sincerity to you, person to person, I believe that some of your comments reflected that that's what occurred. Over the last several months, I believe that's the case. And so I have to, it's my job to ask you again, why the simple clarity of that law was not applied in this case, because the implications here are so profound for your children and mine, for this country. They are so profound. And I again, I don't envy your job, but I want to give you the remainder of the time to help me understand why a law like this that any law school graduate, if we can't apply this one in this case, how in God's name can we apply it in any case in the world? Why is it even written? So I'm going to stop there and ask your forbearance and just go for it.
Sure. No, it's a reasonable question. That is the 18 U.S.C. 1924 is the misdemeanor mishandling statute. That is the basis on which most people have been prosecuted for mishandling classified information have been prosecuted. It is not a strict liability statute. I was one of the people when I was in the private sector who argued against strict liability criminal statutes. It requires, in the view of the Department of Justice and over long practice, proof of some criminal intent, not specific intent to harm the United States, but a general awareness that you're doing something that's unlawful. So you have to prove criminal intent. So there's two problems in this case. One is developing the evidence to prove beyond a reasonable doubt that Secretary Clinton acted with that criminal intent. And second, even if you could do that, which you can't, looking at the history of other cases, what would be the right thing to do here? Has anybody ever been prosecuted on anything near these facts? And again, I keep telling the folks at home, when people tell you lots of people have been prosecuted for this, please demand the details of those cases, because I've been through them all. So that combination of what the statute requires and the history of prosecutions told me, and again, people can take a different view, and it's reasonable to disagree, that no reasonable prosecutor would bring that case. That, in a nutshell, is what it is.
You said it was a reasonable question. It was a reasonable answer, but I can't find that in the statute. Thank you, sir.
Thank you. The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, and I'm going down a completely different path. Our law enforcement in this country have a consistent enemy in a group called sovereign citizens. And what I have seen in my district, we lost 2 officers in St. John Parish about 4 years ago. And we just lost another 3 officers in Baton Rouge with another couple injured. In the case in St. John Parish, we actually had the perpetrators on the radar in North Louisiana. And at some point, they moved to South Louisiana in my district, and we lost contact. So when St. John Parish deputies went to their trailer park, they had no idea what they were walking into, and they walked into an ambush with AR-15s and AK-47s, and the unimaginable happened. So through NKIC and other things, are you all focused on making sure, and I think there are about 100,000 of them, but are you all focused on making sure that our law enforcement has the best information when dealing with whether it's sovereign citizen or terrorist cells or other bad actors, that that information gets to the locals so they're not surprised and
be charged?
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was in his first interview on February. Comment on that, and I don't really care about the decision about whether or not there should have been a grand jury here. But since you didn't have one, it goes to the issue at hand about whether or not this interview should have ever taken place. With due respect to the answers that you've given, the FBI and the Department of Justice absolutely control whether or not an interview is going to take place with other witnesses in the room, because the simple truth is, if, under the circumstances as you've described, those interviews never take place. If there was ever any possibility that something Hillary Clinton might have said on July 2nd could have possibly resulted in criminal charges that might possibly resulted in a trial against her relating to this classified information, well, then to use your words, Director, I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that. So, to me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to.
He never said that he remembered anything from that March 25th phone conversation with the Clinton people. Of course, that was days before he bleach-bitted the emails. He never said he had any factual knowledge of anything that happened on that call. Is that his basic statement? So I read the 302s. He didn't really provide any information.
I can't remember for sure it being the 302. You've probably seen it more recently.
Well, I saw one 302 said that he pled the Fifth. Obviously, he was given immunity. Another said that there was an invocation of attorney-client privilege at one time in one of the other summaries. So I'm just trying to figure out, what happened with Gambetta. Why was he not able to provide information? He had immunity. This was something that was much more fresh in his mind than previous conversations with Clinton people would have been. And yet you said he was credible. To me, feigning ignorance, that is not credible given the timeline where you have the New York Times saying that this server existed. The House immediately sends a subpoena. He has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where these things are now under a subpoena, and he has conversations with people.
To respond to that?
No, fine.
It's a direct comparison to the finding of yourself that, as you stated in your news conference, that no prosecutor would prosecute somebody under similar circumstances.
I understood Mr. DeSantis to be expressing a personal opinion. I accept that at face value. I just haven't seen the cases that show me on the public record that that's true. But I accept his good faith.
The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Director, did you make the decision not to recommend criminal charges relating to classified information before or after Hillary Clinton was interviewed by the FBI on July the 2nd?
After.
Okay, then I'm going to need your help in trying to understand how that's possible. I think there's a lot of prosecutors or former prosecutors that are shaking our heads in how that could be the case. Because if there was ever any real possibility that Hillary Clinton might be charged for something that she admitted to on July the 2nd, why would two of the central witnesses in a potential prosecution against her be allowed to sit in the same room to hear the testimony? Now, I've heard your earlier answers today. You said that, well, it was because the interview was voluntary and they were her lawyers. But I think you're skirting the real issue there, Director. First of all, the fact that it was voluntary, it didn't have to be, right? You could have impaneled an investigative grand jury. She could have been subpoenaed. And I know you've said that you can't.
Who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why did you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI. Again, who knows what people don't tell the director, but I should have asked Mr. Gohmert. If there are agents of the FBI who are concerned or confused about this, please contact me. We'll get you the transparency you need to see that your brothers and sisters did this the way you would want them to.
All right, I'm out of time, but I will say just when I was in the military, you had said no one would be prosecuted. I mean, maybe that was just for civilian, but I can tell you that people, if you had compromised top secret information, there would have been a court-martial in your future, and I yield back.
Would the director care